Okay, all right. Again, happy Tuesday, everybody. So now we are in week 6, which I absolutely cannot believe. It's just continuing to fly by for me. So today's topic is about research. And we have our guest speaker tonight. Her name is Michelle Terrace. She's a law librarian and advanced legal research and writing teacher at Thompson River University. So once again, we would like to take this time to acknowledge that we are on the traditional, ancestral, and unceded territory of the Musqueam, Squamish, and Tsleil-Waututh nations. So again, about AC Friends of Court, I'm sure by now a lot of you have been attending, so you do know about AC Friend of Court. So we are a nonprofit organization. We began in 2011 with its first legal forum workshop being held at the offices of the Access Justice Center at 800 Hornby Street, which is the provincial court building. Our legal forums workshops has helped British Columbians access affordable legal help through a variety of areas of law. At present, we have approximately 45% of our clients that are family law clients, and this is the first type of school in BC of its kind. So again, we would like to acknowledge that this school would not be possible without the generous contributions of the following individuals and organizations. Kylene Wong from Black Robber, Don Batista, Executive Director of AC Friends of Court, Dana Cornwell, Project Manager for the National Self-Represented Litigant Project. It's always a mouthful for me to say. And Andrew Pilliar, who's also a director with the National Self-Represented Litigant Project, the West Coast Division. We would like to acknowledge that some of our work is adapted from resources originally developed by the Justice Education Society, National Self-Represented Litigants Project, and Legal Aid BC. So as a reminder to everybody, AC Family Law School does not give legal advice. These sessions are for legal information only. So just a quick reminder about legal advice versus legal information. Legal advice is answering a question or providing information that is specific and directly linked to someone's case. So I'll just give one example, which is the one we've been using before, is, my ex says that because I moved out of the house, I'm no longer legally entitled to the rights of that house, nor will I receive financial compensation from the house sale. Is this true? So answering that, if I were to answer that, I'd be giving legal advice, which I'm not allowed to do as I'm not a lawyer. So answering any of the above questions would be providing legal advice, because the answer is explaining what your legal rights are and that those answers are specific to your specific situation. Legal information is answering a question or providing information that is more general and not specific or directly linked to someone's case. So for example, I want to start a family law action in Supreme Court. What form do I use and where can I find this form? So asking, if I were to answer that question, that's fine for me to do, because I'm just telling you generally where to find certain things. So yes, answering either above question would count as legal information because it's information received. The information received is general and not directly linked to someone's legal case. So for housekeeping, again, all sessions will be recorded and emailed to the registrants. We remind everyone that the recordings and reference materials are not to be I can't even speak today, redistributed. So thank you everyone for your cooperation. Again, if anybody hasn't received any of the recordings, either check your spam mail or your junk mail. And if you haven't received anything, just email info@litigantschoolbc.com. Please send in your participation agreement if you haven't already. And if you haven't received it, just again, send an email here and then we can send you that participation agreement. Please mute your mic, and you're more than welcome to turn off your video during the session. Any questions that you have, just please enter them into the chat box. And again, just try to keep your questions to more general type questions and not specific to your case. And then just make sure you're respecting each other when you are communicating in the chat box. Please respect the speakers and AC volunteers and staff and other registrants. A reminder that any kind of abusive or harassing language or behavior will not be tolerated. We reserve the right to remove any individual who engages in behavior that the course facilitators determine to be disruptive and abusive or harassing. So now on to the more fun stuff. Now the heavy stuff is done. About our guest speaker tonight, Michelle Terrace. Michelle Terrace works at Thompson River University, Faculty of Law. She is a law librarian. Michelle is the advanced legal research and writing teacher for Thompson River. Michelle became a member of the Alberta Bar in 2016, spending much of her time practicing in rural areas of the province with a developing interest in access to justice for people living outside of urban centers. Michelle has published in the area of anti-propaganda education and often reviews books for the Journal of Information Ethics. She enjoys solving unusual problems in unusual ways and complaining about obscure points of copyright law over tea. All right. Okay, so agenda and objectives tonight. By the end of this session, you'll be able to create search terms to CanLII or in CanLII for useful cases, understand how to read a case, use precedent in your arguments and review precedents from week 2, identify the relevant legislation for your matter, search for and find cases to help support your case. Okay, oops. My turn to stop sharing my screen. All right, Michelle, you can take over.
Okay, here we go. All right, we'll start with a discussion about using precedent. So, before we talk about that, there we are. We need to talk about what sources are used in legal research. So some vocabulary that we'll be using for the rest of the night. The first and most important term is a primary source. A primary source is an artifact that creates the law, and these will include judicial decisions and legislation. It's the main things that you'll be looking at. A secondary source is an artifact that interprets or explains the law. So these are textbooks or journal articles. If you read something on the internet, anything like that is a secondary source. And while we absolutely want to get to primary sources are generally the only things that count once you get into court. It's usually advised that you start with secondary resources because a secondary, well, we'll get to that in a moment, actually. So first I'll mention CanLII. CanLII is a free legal database that's funded via dues lawyers pay to the Canadian Bar Association. Its main purpose is to provide the public with access to primary sources, but it's also expanding into secondary source holdings. So it would probably be the main place that you go when you do legal research. Okay, so we're starting with primary resources and precedent. What's precedent? It refers to previous judicial decisions. So from our favorite law dictionary, Barron's, the doctrine of judicial precedent, whereby a previously decided case is recognized as authority for the disposition of future cases. In the common law, precedents are regarded as a major source of law, different from a civil code. A precedent may involve a novel question of common law, or it may involve the interpretation of a statute. In either event, to the extent that future cases rely upon the precedent or distinguish it from themselves without disproving it, the case will serve as a precedent for future cases under the doctrine of stare decisis. What all that means is that if you have a case from your level of court, say you're being heard in the British Columbia Supreme Court, so your level of court or higher, British Columbia Supreme Court, British Columbia Court of Appeal, Supreme Court of Canada, all of that, the judges can't differ, except in some very exceptional circumstances. They can't differ from what's already been decided on similar matters. So unless you can distinguish, which is to say, tell the judge or decision maker why your case is different from these cases that have been previously decided, the rule from those previous cases is going to apply to your case. Stare decisis, the court is bound by previous decisions. So here is an example or a little explanation of what binding versus persuasive precedent is. Binding means the decision maker must follow the decision. So that's the stare decisis thing we talked about earlier. British Columbia Supreme Court, bound by BCSC, British Columbia Supreme Court, Court of Appeal, Supreme Court of Canada. Persuasive means the decision may be influential, but the decision maker does not have to follow it. So if you're in the British Columbia Court of Appeal, they're not bound by the British Columbia Supreme Court, right? If you're in the British Columbia Supreme Court, they're not bound by the Alberta Court of Queen's Bench, which is the same level. They call it a different thing in Alberta. But those cases are still persuasive because presumably the case law is relatively similar. The other justices heard and you know, the reasoning generally made sense. It would be odd if it significantly differed. So unless the legislation is significantly different. So very persuasive, but they don't have to. So in the words of Courthouse Libraries, BC, under the doctrine of stare decisis, a decision of a higher court is binding on a lower court in the same jurisdiction. So jurisdiction here, we're talking about provinces, although the Supreme Court will be binding on everyone. The decision from the court of another jurisdiction acts only as persuasive authority to varying degrees. The degree to which a non-binding decision is persuasive is dependent on its originating jurisdiction and its level of court. So if your case was being heard in the Supreme Court of British Columbia, a decision from the Ontario Court of Appeal would be more persuasive than a decision from the Ontario Superior Court of Justice, but neither of those are binding. So good to know. Sometimes you just won't be able to find when you're doing your research anything that seems really applicable to your specific situation from your jurisdiction. And the only thing you can do there is look at persuasive cases instead of binding cases and decisions. So we've got our examples. Supreme Court of Canada decisions, always binding, including on the Supreme Court of Canada itself. Provincial and territorial courts of appeal, binding on the appeal and lower courts of their province or territory, and they're only persuasive outside of that territory. Then provincial and territorial courts are binding on superior courts of their own province or territory. Again, they're only persuasive outside of that province or territory. Same with going up. You can't use a British Columbia Supreme Court decision and say that that's binding on a British Columbia Court of Appeal. It's not. Okay, we'll do a little activity. We can do this with the chat if you are so inclined. Or you can just chime in. It's all right too. Suppose your case is being heard in the Supreme Court of British Columbia. Decide whether decisions from the following courts are persuasive or binding. The Prince Edward Islands Court of Appeal. What do we think? You're in the British Columbia Supreme Court. Persuasive or binding? There we go, chat.
We got one. We got one persuasive.
Yes. Yep. All right, good. People are getting it. Yes, it is persuasive. That's Prince Edward Island. So it is not binding on British Columbia. Different jurisdiction. Good job, guys. The Supreme Court of British Columbia. Is the Supreme Court of British Columbia persuasive or binding on the Supreme Court of British Columbia? Yes. Okay, we are getting it. Binding. Excellent. The Supreme Court of Canada. Right. Again, binding on absolutely everything 100% of the time. I will say binding on all courts 100% of the time. If you are doing something in front of a tribunal, always check what the rules of that particular venue are. Binding on all courts. The British Columbia Court of Appeal, binding or persuasive on the British Columbia Supreme Court? It is binding. So the British Columbia Court of Appeal is one up. And this is really confusing. It was confusing for me coming from Alberta, because in Alberta, you've just got provincial court, court of, when I was practicing, Queen's Bench, now Court of King's Bench, Court of Appeal, Supreme Court of Canada. British Columbia calls what Alberta has as the King's Bench the Supreme Court, even though it's below the appeals court. So that's important to remember. In BC, you've got some small claims that are handled through a mediation venue. Then you've got the provincial court. Then you've got the Supreme Court of British Columbia, and then the British Columbia Court of Appeal. So that naming scheme can be very confusing. And the Supreme Court of Canada is above that. Okay, Alberta Court of King's Bench, last one, persuasive or binding? There it is. Everyone's getting it. Persuasive. Great job, guys. Okay. How to use precedent. Oh, is there a graph that shows the levels? There is online. I believe the Government of Canada has put one out. I don't think I have one in the slideshow, though.
I can take a look and find it for when I send the recording out for everybody.
Fantastic. Thank you very much. Okay. How to use precedent in an argument. So precedent is used by analogical reasoning. And if you didn't spend too much time in philosophy courses like me, that means that you want to take example A, which is the existing decision, things that have already been decided, and explain why its relevant characteristics are similar to example B, which is your case. So take things that have been previously decided, apply them to the decision that will be coming out of your situation. You will either want to show why the rule from a previous decision should be applied to your case or why it should not. When you're showing why the rule from one decision should not be applied to your case, that's called distinguishing. So you're distinguishing your set of facts from the previous set of facts. How do we do that? So analogical reasoning. Reasoning by analogy works by inferring from the recognition that two items share some traits, that they share an additional trait that one of them is known to possess, or by judging that because two items share some traits that they should be characterized or treated in a similar way. To be persuasive, the comparison must appeal to a sense of intuition that the additional trait is likely to accompany the existing traits, or that it would be wise to treat the two items similarly on the issue in dispute. So if I say, Mary really likes the flavor of lemons, and Mary really likes baked goods, we can say, therefore Mary probably likes lemon loaf, right? These things make sense together. It would not make sense to say Mary likes, what's the difference between arguing and making an argument? I'll get back to that in 1 second. We would not say that Mary likes lemon loaf, has these two things, likes lemon loaf, and the next person, likes the flavor of lemons, enjoys baked goods, owns a Hyundai. That doesn't follow from what we've originally set up. So this is the key point of relevance. What's the difference between arguing and making an argument? That would be a little bit philosophical. I think there's a Monty Python sketch about that with the dead bird. No, not with the dead bird, where he argues about having an argument. When you're arguing, that has more connotations of just having a spat, which is something that you do in regular life. When you are making an argument, you are standing up in front of a court and you are putting forward your position. So just a different connotation. They could be used interchangeably, but one has more of the feeling of delivering a set of reasons than the other. Okay, so analogical reasoning is the basic pattern of legal reasoning, reasoning by example. It's reasoning from case to case It's a three-step process described by the doctrine of precedent, in which a proposition descriptive of the first case is made into a rule of law and then applied to a next similar situation. The steps are: similarity is seen between the cases. Next, the rule of law inherent in the first case is announced. Then the rule of law is made applicable to the second case. These are the fact situations. This is the rule arising from the first case. Because the facts of these two cases are similar in a relevant sense, the rule of law applied in the first case should be the rule of law applied in the second case. The facts in a case may fall outside the ratio of an existing precedent, and thus the court is not bound by the precedent. Ratio just means it's related to the actual decision, not just a thing that they were talking about. That's obiter. On the other hand, the justification for the earlier decision may apply to the later case and thus provide an argument from analogy. So this allows the court to extend its reasoning from a previous decision. Analogical reasoning, like inductive reasoning, operates on probabilities rather than certainties. So this is why you ask any lawyer any legal question. The answer is always, it depends, because everything is incredibly fact dependent, but also because all legal reasoning operates on probabilities rather than certainties. And this is why. So, just to give you a visual sense of what we're talking about, there are two methods of analogical reasoning. The first is analogical reasoning by properties. So the previous decision, X has traits A, B, and C. Your case, Y has traits A and B. So then you say it's probable, therefore, that Y has trait C. So your example here, soccer equipment is reasonably priced and supports a child's healthy exercise, and the courts view it as an acceptable expense. Swimming equipment is also reasonably priced and supports a child's healthy exercise. Therefore, the courts will probably view it as an acceptable expense. So we took reasonably priced, supports a child's healthy exercise. Those are the two traits that they have in common, and we are trying to apply, the court will support this from case 1 to case 2. When attempting to distinguish a decision, that is to say, we don't want to apply the rule, we explain why the relationship between the previous decision and your case is insufficient. So why the characteristics compared are not relevant to the conclusion. The second form of arguing is arguing by analogy, is arguments by relation. So where R is a relation, X is to Y as A is to B, right? X is R to Y. It is probable, therefore, that A is R to B. We're looking at the relationship between two factors. So the example from the paragraph we have below, innkeepers are to boarders as steamboat owners are to passengers. Innkeepers are strictly liable to boarders for the theft of their vulnerables. It's probable, therefore, that steamboat owners are strictly liable to boarders for the theft of their valuables. Right, so that's not usually articulated so simply. We can see below here, this is an older case, so the wording is always a little bit more complicated, but a steamer carrying passengers upon the water and furnishing them with rooms and entertainment is, for all practical purposes, a floating inn, and hence the duties which the proprietors owe to the passengers in their charge ought to be the same. Okay, activity, strong or weak arguments. Carlotta likes cats and eats fruitcake, and she lives in Prince George. Mai also likes cats and fruitcake, so she probably also lives in St. George. Strong or weak argument? Okay, good. Yeah, everyone's seeing weak. Weak, because there's not enough of a rational connection between liking cats and fruitcake and living in St. George. So we can say if someone tried to apply a rule from one case to our case, and we didn't want it applied, or we didn't think it should be applied, well, there's not enough of a connection between the factors you've listed, no rational connection or not enough, in order to actually tie it to the conclusion that you want. Okay, strong or weak? Carlotta likes fruitcake, stolen bread, and candied fruit. Mai also likes fruitcake and stolen bread, so she probably also likes candied fruit. Strong or weak? We're getting more answers of strong, and that's good because fruitcake and stolen bread and candied fruit are all pretty similar, right? If somebody likes fruitcake and another dessert made of candied fruits and nuts, then they probably like one of the ingredients in that. There is a rational connection being made. So it's a stronger argument. Okay, relational. Chicks are to hens as ducklings are to ducks. Chicks follow hens after they are born. Therefore, ducklings probably follow ducks. Strong or weak? This is where we get into arguing, right? This one, I think, could go either way. There's no right or wrong answer here. And this is where lawyering comes in and being creative with your arguments, because again, this is why it's all probabilities. You could say the relationship is strong because they're both birds, because the way that their relationship works is the same. You could also say, oh, it's weak. The reason that chicks follow hens is actually completely separate and has nothing to do with the relationship between ducklings and ducks. So it's all about your creativity in making the argument for this one. Okay, now we're going to get into how to distinguish a little bit, getting you to think about how to make those arguments. So a town sewer was damaged by a flood. Damage was immediately caused to a property attached to the sewer line. The town was not found liable for the damages. Now say it's your case. A town sewer was damaged by a flood. The town was given notice to repair the sewer. The town did not repair the sewer, and damage was caused to a property attached to the sewer line. The conclusion the town wants to make is the town should therefore not be found liable for damages. Can anyone think of a reason to distinguish these two situations? This is going to take a little bit longer to type. That's right. In the first situation, the town had no time to repair anything. They had no notice. Whereas in the second situation, the town was given notice to repair. They had time. They didn't use it. So that is how you would attack that argument, how you would distinguish between the two. Okay, family law. The child has been playing hockey since the age of 5, current age 15. The court accepted that the child is extremely talented and that the combined income of the parents is $352,000. The court held that rep hockey was a necessary, extraordinary expense. Different case, your case, you're trying to distinguish it. The 14-year-old child has been playing hockey since the age of 6. The combined income of the parents is $100,000, and evidence was not submitted as to the child's talent. Therefore, one side says the court should find that rep hockey is a necessary, extraordinary expense. How would you distinguish between these two cases? There are a couple ones you could say here. Yep, first kid, extremely talented. So we have evidence on that. Evidence was submitted. In the second scenario, no evidence was submitted as to talent. There is one more major thing. combined income difference. Yeah, that's what it is. So $100,000 is very, very different from $352,000. And rep hockey is expensive. Health of the child is a good thing that you would probably point out if you were pro this, making this argument, saying health is very important. It's in the best interest of the child. It's not relevant to distinguishing the argument that's on paper here. How long they were playing is also on there. 2-year difference is not going to be too much, right? So you're looking at the big picture things, and it's really hard, especially when you just start doing research, to figure out which of these factors is going to be the major thing that's going to either distinguish or link them together. 2 years, probably not a huge amount. $250,000, that's going to be big. Okay, conclusion on this. When you're looking for a precedent, you select based on whether it's binding or persuasive and whether it's logically relevant using your analogical reasoning. All right. Finding legislation and using the Courthouse Library's website. Sources. So there are a number of ways to determine which pieces of legislation apply to your case. And these include reading a reliable secondary source, such as a textbook written by an expert. When explaining a concept, a good secondary source will highlight both leading cases and relevant legislation. This is the best way to start legal research. So that way you don't have to just type in search terms over and over and over again and hope you find the right piece of legislation. If you read the leading textbook in a particular area, it's just going to tell you, and you're going to know that you haven't missed it. So you search for your key terms, you filter to your jurisdiction, and then read the cases that come up. This is the other way of doing it. These decisions will have to reference the legislation relevant to their subject matter. So if you're reading a case and it's governed by the Family Law Act, it has to reference the Family Law Act, right? This is a more time-consuming method of legal research, and it increases the chance that you'll miss a relevant piece of legislation. You'll have to go there at some point, but starting with secondary sources is much easier. So where do we find them? Because they can be very expensive, and we don't want to be paying for a bunch of legal textbooks. For that reason, the best place to access them is usually your courthouse library. You can search the library catalog by navigating to www.courthouselibrary.ca. The link will be in the slide for you. And then by switching the search selection from websites to library catalog. So you just want to search the website, you can leave it, but if you want to actually go to the library, hit the button. Can an expert report be included in submission without having the expert as a witness? Should notice be given to the other side? We'll get, those are a little specific for what we're doing right now.
Yeah, this is going to be, this is more based on evidence than it is about like the research and backing up your case. Yeah. So we're going to hold off on that question for right now.
Okay. You can start your research broad and then move narrow. That is the entire, well, it's a huge pattern with legal research. Always start broad and move narrow. Here in this slide, I've searched for family law, and I'm looking for a good introductory result, right? So first result, J.P. Boyd on family law, resolving family law disputes in British Columbia. That looks fine. So we're going to click into that. And we see that it's a book, but it's also available online. ClickLaw Wikibooks is available at wiki.clicklaw.bc.ca. And is another great resource for finding secondary sources to begin your research. But here, once we've clicked into it, we're looking at the catalog. We can see that the book was published relatively recently, that a version of it is online, and at which branches a physical version is available. So recency is a big way that you want to judge what you're looking at, because there might be new leading cases. If your book is too old, the cases that were good law might have been overturned. There might be a new version of the statute, all these kinds of things. So you want to keep it relatively recent. To only view books that are available online, so you can't get into a courthouse, you can select the available online filter on the left-hand pane after you run your search. If you do want to take out a physical book or want to request that 5% of a physical book or one chapter be scanned and emailed to you, you need to click the register button on the main page and create a free account. And once you have that account, just click the request copies or borrow a book buttons at the bottom of each item's entry. Pretty easy, pretty much like using a public library, right? Other courthouse libraries, secondary resources. The Courthouse Library's website also has a number of reliable and informative articles, as well as remote access to Irwin Law textbooks for those who register for a library account. The Irwin Law books are great. They're excellent introductory sources, very comprehensive. They do the Canadian Essentials series. The articles can be found in their legal knowledge base, so be sure to check in with your local courthouse law librarians for even more information on the resources they make available to the public, and they'll be able to tell you about anything specific to their courthouse that they can help you with. Now we're going to get into oh, sorry.
Actually, I have a question.
Oh.
So for the courthouse library, do you have to be a lawyer to be a member, or can you sign up like for the online account?
You can sign up whether you're a lawyer or not.
All right. Okay. There we go. Good to know for everybody.
There are some things that are restricted to members of the bar, but it's you can still sign up, access books, anything like that.
All right.
So CANLI is going to be very important for you. This is going to be the majority of your primary law research. So let's talk about how we use it. You'll see once you go to CANLI, the very top bar is searching document text. The next bar down is searching by document title. People confuse those all the time. If you just search the document title, but you're actually looking for something embedded in the text, you're not going to find it. So when in doubt, check the document or use the document text button instead. Unless you're looking for a particular case, that's where you start typing in document title so that you only get that case and not cases mentioning that case. You can also browse by looking at primary law. So you can see it's got Canada, British Columbia, Alberta, Saskatchewan. We now know why it's important to break things down by jurisdiction, because that determines whether something is binding or persuasive, right? The way that we search CANLI and any other database really is using Boolean operators. Boolean operators are the word math that we use to construct search queries in a database. You can use Boolean operators in CANLI, but also on any database you have access to. And you can even use a special set of operators to more efficiently search Google and Google Scholar. So one example is if you are looking up Jaguar and you don't want to hear about the car, you can type in Jaguar minus car on Google and just get information about the cat. Boolean operators are sort of, so English language in general, how many times can I start this sentence? Language in general is very difficult for computers to understand. You hear a lot about natural language processing. It's very, very tricky. So Boolean is like translating human speech into a type of speech that machines can understand. So it uses a bunch of different operators. The AND operator is probably the most obvious. So I'm looking for chocolate and vanilla. This gets confused with OR a lot. So looking for chocolate and vanilla doesn't mean it could be anything chocolate or anything vanilla. It means it has to have both, right? So I'm looking for hockey and equipment. I'm only getting results that talk about hockey and equipment in the same document. So for chocolate and vanilla, sundaes, ice cream sandwiches, Neapolitans, yes. Brownies, vanilla beans, chocolate chips, no, because they don't include anything about the other. Not. So I'm looking for chocolate, not vanilla. Only those results about chocolate that do not include vanilla. So if you are looking up, something about extraordinary expenses and you've read everything to do with hockey and you just don't, it has nothing to do, you can distinguish it pretty clearly from what you're wanting to look up, remove it. Just say extraordinary expenses, not hockey, and it'll take out results that discuss hockey. Chocolate or vanilla. This is just all the results. It is opening up your search as broad as you possibly can. So results that are only chocolate, results that are only vanilla, and results that are both chocolate and vanilla. Parentheses. This is a little more complicated. Now we're getting into, if anyone remembers their order of operations from high school, that's what we're doing here. So the things that happen within the parentheses, those operations happen first. So chocolate or vanilla and strawberry. Chocolate or vanilla, that means we could do anything in those two circles, right? In the first Venn diagram, the whole thing, but it has to include strawberries. So we're saying anything in those first two circles, but only the results that include strawberry. So that's what that looks like. And it performs, excuse me, the or operator first, because you've put it in parentheses. So you can get more complicated, do a lot of really precise searching this way, right? You can get much more complicated as you go along. Quotation marks. Quotation marks are going to be very, very important for your search. So these are for a phrase. So you want all of the words in the quotation marks in the order and proximity that you wrote them in. So you are looking for the phrase, best interests of the child, put it in quotation marks. Consumer goods, foreign registered ship, these are things that appear in the legislation. This is the term that they used. It's probably the term that's coming up in the case. So it's not searching the text for the words best and interests and of and the and child, which is what it would have searched if you put it in with no operators. Although it doesn't actually tell you, each database doesn't tell you which operators it's using between the words. So sometimes in some databases it's and, I think Canly is and, other databases use or and just give you this maximized sprawling result. Proximity searches, also fantastic. So proximity searches come in 3 standard flavors: searching within the same paragraph, within the same sentence, and within a user-defined number of words. These are some of my favorite because it allows you to think about how a person would phrase something, the different ways a person might phrase something. So within the same paragraph, you're more or less just saying, okay, I've looked up hockey and extraordinary expenses, but those are appearing like hockey is being talked about, but not in connection with extraordinary expenses, like they're being talked about in 2 different parts of these cases. And I want them to be talked about together. I want to know whether hockey equipment qualifies as an extraordinary expense. So I'm going to say hockey equipment, probably in quotation marks, hockey equipment /P, and then in quotations again, extraordinary expenses. And that would put the phrase hockey equipment in the same paragraph as the phrase extraordinary expenses. Same sentence, same idea. /N, the N is just whatever number you want it to be. So if I have been reading some cases and I thought best interest of the child would always come out best interest of the child, but I'm noticing that some judges are saying the child's best interests. And so when I put it in quotation marks, that's a bit of a problem because that's not going to come up. Well, I look at the way it's phrased and say, okay, best interests always seems to be together. So I put that in quotation marks. And then it's always within 3 words of child. So I would say best interests /3 child. And that's how I would do that search. So this is just so you can see how you can narrow it down. So if you use /P between the first two here, security, interest, and judgment creditor, you get 116 results. If you use same sentence, 73 results. Within 15, 64. Within 5, 25. So just to show you how quickly you can narrow down your results. If you're not finding that putting something in the same paragraph is creating enough of a logical nexus between the two. So these are examples of search string and search string progression, how you might work on a problem going from broad to narrow. So just extraordinary and expense and extracurricular all in the same decision. That's what the first one is, right? Lien, not foreclosure. You're going to get a lot of results. You're going to have to sift through a lot of things. You start making it a little bit more complicated. I do advise when you come to words that have dashes in them, no one knows how to use dashes and hyphens. So just assume that the clerks typed it every possible way, like post-secondary, right? Post-secondary, one word, that's the wrong spelling. It doesn't mean no one spelt it that way. Or post-secondary, 2 words, or post-secondary with a dash in there. Now you've captured all of those possible results. And then we get down to the last one here. A good example of how or is used, generally speaking. So best interest of child, great. And hockey within 25 words of, and then I've made this so that all 4 of these words are kind of, we're able to look at them and how the phrase might come together. So unreasonable or extraordinary, because you've seen it written down as an extraordinary expense. You've seen it written down as an extraordinary cost. You've seen unreasonable expense and you've seen unreasonable cost. So writing it out like this allows you to switch those words in a single phrase without having to run multiple searches, right? And just putting them within 5 words of each other to account for how someone might have phrased that. You don't need to make it this complicated. I'm making it complicated to show you the maximum that you can do with it. But just to understand that these operators exist and how you can basically use them will take your search time down substantially. Filtering. Filtering is next. Filtering is what you use when you have a bunch of results and you need to narrow them down. It means taking your search string and using a database's limiting options to narrow those results. So your first filtering option will be a choice between viewing all of the results, all of CANLI, which is the default option, just the cases, just the legislation, or just articles commentating on certain cases. That's your commentary. So filtering results by jurisdiction. Remember that this is important because of how stare decisis and what's binding and what's only persuasive works. In all CANLI cases and legislation, you'll be able to filter by jurisdiction. So it's useful if in situations in which you're researching a topic governed by a provincial statute, like the Family Law Act, where the law might be different in, for example, British Columbia and Alberta. So if it's a federal statute, it matters a little bit less. But if it's a provincial statute, you really want to look at how your jurisdiction has interpreted your jurisdiction's laws. Level of court. This is the other thing we talked about with, is it binding or is it only persuasive? So if you've clicked into the Cases tab, you can filter your results by level of court. And this is useful if you want to find a precedent that's binding rather than persuasive. You can also filter by date or by subject. Although be a little bit careful because the subject tab is created using an algorithm that has little human oversight. So it might exclude certain cases. You'll get a core set of cases that are definitely accurate. You might be losing some periphery cases. The latest versions. In your legislation tab, you can set your results to only see the latest version of a statute or regulation, excluding past or repealed versions. You usually just want to see the most recent version. The only exception would be if something happened and it happened during the time when a previous bit of legislation was in place. But that's pretty tricky. Normally, you want the most recent version. And it's usually a criminal law thing. Filtering results, result order. So one level down, you can change your result order so you can filter the documents by relevance. That's the default, what has the most hits for the search string that you put in. But if you're finding just a ton of results, you can also see by newest to make sure it's still good law, or most cited, or highest court level. Most cited would be that this is a very famous case, so we want to see if we can apply this rule, something like that. Reading cases. How we read cases. First, we'll start with the meta information. Meta information, metadata, just means data about data. Meta information means information about information. So an entry for a case will appear as follows on CanLII. You've got the names of the parties involved. It's called the style of cause. And then it's for the past 20-ish years, you've got the neutral citation, so the year, the jurisdiction and court level, and then the ordinal number. So what we're seeing here is that this is the 192nd case decided by the Alberta Court of Queen's Bench, now King's Bench, from 2005. Where ABQB is written, you will ideally see BCSC, British or Supreme Court of British Columbia, or BCCA, the British Columbia Court of Appeal. So those are the things that you're looking for. You can use this information to determine if you found the correct court level and the correct jurisdiction, and to determine how recent the case is. This entry is called a neutral citation. That's the year, jurisdiction, court level, and ordinal number. It only began being adopted in Canada in 2000, so older cases will look a bit different, but they'll still start with the names of the cases, right? Once you click into the decision, there are tabs that explain the appeal history of it, which cases it cites, which cases cite it, and whether CanLII hosts any articles about it. That can be very handy because reading cases and case law is initially very hard. So if you can just read an article that explains it, maybe it's a case brief, maybe it's explaining how it affects that area of law, you'll get a much better sense of what the case is actually saying. So if you plan to rely on a case, you need to check the history and treatment to be sure it's still good law. This will be covered in the lesson on noting up. Just make sure if you're citing a Supreme Court case or British Columbia Supreme Court case, it hasn't gone up to the Court of Appeal or the Supreme Court of Canada, because the rule that you're citing might have been overturned by either one of those, right? Cited documents is where you will find what legislation the decision references. So if you're looking for something based on the Family Law Act, you can go into cited documents and see, yes, this is the Family Law Act, or you've read a case that you think really applies and you want to say, well, what legislation governs this area of law? Go on and check in cited documents. It's there. Reading head notes. A head note will give you quick information about a judicial decision. And I have speaker notes about that, so I'm going to move people over here. There we go. It'll always include the name of the case, the neutral citation post-1999, the parties, and the date on which the decision was handed down. And it occasionally includes a case summary, very handy, usually at the Supreme Court level. Cases, statutes, regulation, treaties, authors, etc., cited or considered, and then the subjects that it touches on. So why is this useful? it helps you figure out whether this is what you're looking for without having to read like 600 paragraphs if it's a monster like Vavilov or something like that. It can clarify the major points that a case stands for. So this is like when I take my dad to go see Shakespeare and they give us the little pamphlet and we look at that and say, oh, okay, we have kind of an idea of what is going on before we start the play. And so when we listen to it, we have a better understanding because of that. If you read the little thing that tells you what's going on, it's going to map onto your brain and stick there a lot better than if you just go into it cold. It gives you the information you need to cite the case, because you'll always need to cite the case so that the other side can check it. And so the decision maker can check it and say, yes, I agree with you. This is good law. And it definitely does apply here. And it can include keywords and phrases to improve your search. The funny thing about searching is that you'll often start, even lawyers start, maybe not knowing a huge amount of vocabulary about that area of law, because each area of law has its own terms of art, its own weird Latin, a way things are typically phrased. So someone who usually does wills, it might take a while for them to pick up on securities, things like that. So as you go through and read, and this is part of why we start with secondary sources, you get a feel for what words are actually coming up generally in these cases. And that will increase the accuracy of your searching when you start to use those specific words to put together your search strings. Okay, then there are the sections of a decision. After the head note, a decision will typically include a facts or background or introduction section. This is great for when you are checking, do the facts of my case actually line up with the facts of this other case that has a great rule that I want to rely on? Or how might I distinguish? I've been handed this case. How might I distinguish between the facts that I've been given and the facts of my situation? It'll usually list the issues somewhere so you can see right off the bat if this is relevant to you. It'll have an analysis section. This is the meat of the entire thing. So once you decide that it's relevant, you go in and decide and try to figure out on what basis it's been decided. What is the logic behind the decision? That's where the decision maker writes that down. And then a conclusion or summary. And it can be nice to kind of skim down, look at that first if there's no summary or at the top in the head note, and then look back up and just get that feel for, okay, now I know what's being decided. Now I know what this is leading up to. It's going to help me understand when I go to read the analysis. Okay, the issues, very important, but these sometimes just appear as headings in the analysis. So if there's no separate section for them, sometimes you can scroll through the analysis and just look at the headings. Those are going to be the issues. Check the analysis again to see how those issues are resolved, and the conclusion will have a quick breakdown of how the case was decided. Sadly, not all decisions have this section. I really think they should. Okay, that's the end of it. We're at the Q&A section. Does anybody have any questions? That was a lot.
I'm impressed you went through all that like in an hour.
Everyone wants to get to dinner, right? Oh, thank you.
Does anybody have any questions related to research or case law or any of the terminology you heard today? I noticed a few times you said the word jurisdiction. Are you able to explain that term for anybody who doesn't know?
Okay. So again, I'll go back to family law because that's what I started out doing. So for the example, there is a different family law act that applies in Alberta than the family law act that applies in BC. They're called the same thing, but they're different. So your jurisdiction will be the Oh, yes, precedent is the common law. Yeah. So jurisdiction is the area in which a certain law or a set of laws apply. So there's the federal jurisdiction, but there is a distinction in the Constitution, Section 90 versus Section 91 powers. So even though geographically Canada is Canada, the federal government only has certain powers within Canada, and each of the provinces have certain powers. So you have to figure out which set of powers you're looking at, or which set of powers apply to your case. Is it federal or is it provincial? If it's provincial, then your jurisdiction is British Columbia. If it's federal, your jurisdiction is Canada. Although I shouldn't say that. Black line, absolutely, because there might be a conflicts of laws issues if your partner is in Nova Scotia and you're in British Columbia. Then you might first have to figure out which jurisdiction applies. Is it the rules from Prince Edward Island, or is it the rules from British Columbia? So those have implications in terms of what legislation you're looking at, but then also what case law you're looking at. Okay. Jurisprudence. Jurisprudence is used in a lot of different contexts in law. So in probably not the sense you're talking about, jurisprudence is legal philosophy. In the sense that you're likely to run into it every day, jurisprudence is the body of decided laws, so the body of case law in a particular jurisdiction. So the jurisprudence of British Columbia in relation to the Family Law Act is just cases that have already been decided in BC that are relevant to this particular piece of legislation. Okay. What are the benefits of doing research before you go to court? I assume it's good to have an argument about your case in front of the judge. Can you refer to a particular case in front of the judge? Yes, you should refer to a particular case in front of a judge. Law is all about precedent, at least in common law jurisdictions. And we are a common law jurisdiction. Anything that came from England, common law. So you need to have done the research, because that is 100% of how it's close to 100% of how arguments are made. You can say this is the statute, and this is why it applies in this particular instance, but a lot of the time, a significant amount of the time, you're going to rely on a case that has already been decided to prove that that's actually how it applies. A lot of times there are going to be lines of thinking that aren't even articulated in legislation. It just comes from the case law. So you have to know absolutely 100% what legislation applies, that statute and regulation. Statutes are things that are passed by Parliament or a legislature. Regulation, as you're reading a statute, you'll notice it says the Governor General or Canada Heritage, or whatever it is, has the ability to make certain regulations from time to time, blah, blah, blah. Statutes are like if you drew a picture, and regulations are like if you shaded it in. So you do have to have an understanding of both. If the regulations apply, a lot of times it'll just be a statute, and it'll be pretty straightforward. So you have to know the statute. You should take a look at the case law that interprets that statute, because sometimes you think a statute says one thing, and it's been interpreted in a way that you might find extremely counterintuitive. And if the other side knows that and you don't, you're going to lose really, really fast. Let's go Vavilov. So when you're on CanLII and you scroll down and you say, this is all of the head note, by the way, because Vavilov is a very complicated case. It goes on for quite a while describing it. So let's say I've read paragraph 30, and I want to say paragraph 30 says something extremely important to my case. It articulates the rule of law, or it has a fact, right? I'm saying these are the facts from Vavilov that should, therefore make it apply to my case, whatever. If you go over to this little button here, paragraph tools, you can copy the citation, which is important because you will need that in court. But more important right now, you can go to citing documents and see that there are 149 documents that cite just that paragraph. This is unusual. It's a big case. So there are 3 articles that have been written just about that paragraph, or there are 145 cases. So you can read those 145 cases to see how that paragraph has been interpreted, and it works the same way for legislation. So let's look at the Family Law Act, SBC. Let's scroll down here and see. Okay, best interest of the child, of course, comes up in almost every single family law case where children are involved. So I'm going to click this and see that there are 667 citing documents, 658 cases specifically. So 9 articles, 1 piece of legislation. That's probably a regulation that's related to this. I'm going to look at the cases, and I can see there are all of these cases that are specifically talking about best interest of the child. If I don't want to read 658 of those cases, I can look up whatever I think is relevant about best interest of the child. Let's say I'm thinking health. Health comes up a lot. 589. Of course. I can also say, okay, section 37, there are subsections of section 37. So I'm only interested in looking up section 1, subsection 2. There we go. All jurisdictions should just be British Columbia. Yes, good. And if you just go with section 1, it'll include all of these, right? So there was 1 extra case that we added there. There we go. So section 37. So that's how that works. Okay, let me pop up Zoom again. I'll stop sharing my screen for now. Come back in a moment. We need it. Is CanLII updated regularly to reflect new decisions? Yes, CanLII is updated very regularly. There are online reporters that you can pay for, like Westlaw and Lexis. They're not better than CanLII in terms of getting cases for recency. CanLII is really, really good. It actually gets money. It's not like some of the other countries like Bailey or just Lee from the States, which are very unimpressive. CanLII does a really good job. It's a really good resource.
All right. Does anybody else have any questions? Or is everyone just like me where I'm like, wow.
I know it's so much. This is, oh, good. Yes. Question. Let's go. Now we wait.
The pressure is on now.
If it were me, it would be just nothing would be spelled right in the ensuing comment.
Yeah, exactly. No, I'm really impressed with CanLII. Like it's definitely like each year I find it gets more and more like the resources they have. I know they do have some like like manuals,
Oh, yes. Why don't
articles.
I'll answer this question. Oh, I think this is a you question. That part where she went through the example, will it be included in the video link? Oh, are we still recording? Yeah, we're still
Yeah,
recording.
yeah, we are. Yeah, we're still
Uh,
recording, so it'll be included.
okay, so I'll just share my screen really quickly again. We'll go back to Canly. Oh, place I was at earlier. Okay. So this is Canly commentary down here. This is where you can look at some other free secondary resources. They're not all spectacular. Some of them are just written by a random law student. You'll be able to tell when you see that, though. The books, however, are not. So if you go into books, articles, reports, and more, you can see Canly Connects. Canly Connects can be written by a law student or by someone who actually practices in that area of law. Usually it'll have the author's name beside it, so you can look them up. If it's a real live lawyer, typically they're doing it for some level of firm advertisement. So they will have the name of their firm and their practice areas beside it, and you can decide whether or not you trust them. They also have this Canly Authors Program. It's a little bit like being verified on, I was going to say Twitter, but I guess X now. So someone has actually gone through and looked and said, yes, this is a good legal researcher. They know what they're talking about. So little maple leaf with a quill. You can also look up books, articles, reports and research papers, journals, newsletters. This is complicated. Usually when you're making a policy argument about why a certain section was created, what was the reason behind it. So you're arguing legislative intent at that point. Books are probably going to be more where you want to start. And so it starts with authors, or you can filter here. Something I will absolutely recommend, Canly put it out themselves, so you can just go to the Canadian Legal Information Institute. And Control F here. No. Yes, the Canadian Legal Research and Writing Guide. Great place to go to find extra tips and tricks. It was written by Catherine Best initially, so it used to be called the Best Legal Research and Writing Guide, and I'm very disappointed that they changed it. But if you click in here, there's lots of really good stuff. I like their checklist. Oh, I can't see anything. Here it is. So it has a checklist in here. Restate your issues, when to stop. That's important. When to stop is basically when you're finding the same cases over and over and over again, you've probably exhausted an area. Step-by-step legal research process, really spectacular. Searching Canadian case law, restating the issues to refine your strategy, getting stuck, all of this kind of thing. So we'll take a look at the checklist. Using a research checklist, they have a sample checklist. So this can just help you to think of new places to look. It can help you to ensure that you've done an exhaustive search. It's just nice to have checklists for things. I really enjoy them, so I like to point out that they're there. It's a great resource to just go back to if you have a moment or if you're feeling overwhelmed. They explain the whole process really well, and it's Canly specific, which means it's specific to a resource that you will absolutely have access to.
Okay.
Okay. You can make novel arguments. You can always make novel arguments. Are they risking error?
That would be unfortunately borderlining on some legal advice.
Okay.
For some of this stuff, when it comes to writing out arguments and presenting your case in court, if you can, I would wait for week 10. Week 10 is getting ready for appearances and trials. I think it's going to touch on that. So it's a little bit hard to, talk about that today. When it comes to, drafting arguments or what is called your submission, which is basically like your on paper, I'll call it a story, what explains to the judge why you're then and there. That's where you can start throwing in some of your case law that you find, if you're referring to something very specific that you think is going to help you.
Yeah, I'll just say you're going to be a lot more, you want to stick to precedent. You always want to be able to say, case A was decided this way in the past. This is relevant in these ways. So my case should be decided the same way as case A.
All right. Does anybody else have any questions? Otherwise, you said it. I think you set a world record here. Very fast and a lot of really good information. Like I think just watching you even fiddle around on Canly, I learned more about how to really fiddle around on Canly. Like I go to the usual places. Okay, this is where I'll go look up specific wording. This is if I want to try to find a specific case. If I want to look at legislature. But watching you just whip through it, I'm like, oh, look, there's more stuff you can do. And it is a lot of information. It's a lot of good information. So if anybody walks away today with kind of like, I need to sit down for a few minutes, that means that's good. That's always good. That's how and it's weird because for me, when I learn something, if I'm like, my head's doing this by the end of it, that's a good thing, I think.
Oh, my students very rarely have questions at the end of class. It's usually like wandering in a day or two after the lecture and I was doing the thing and now I can't figure out how to get X to do Y. That tends to be how it works.
Yeah. And again, if anybody has any questions that pop up during the week specific to tonight, just send it at info@litigantschoolbc.com. And Michelle, if it's okay, like if they do have questions, if I can ask you and then I can then, be the middleman for that. Yeah, so I feel like we set a world record, and if nobody has any questions and everyone's just like, you know what, I want to go and rest and have a nice Tuesday. Over here it's still pretty rainy. Otherwise I'm going to stop the recording.